When a marriage or civil partnership collapses, the family practitioner faces an immediate strategic choice. The advice they provide dictates the distribution of assets and the specific level of legal protection the client retains throughout the process. The standard legal mechanisms to end these unions are divorce for a marriage and dissolution for a civil partnership. Both pathways completely dissolve the legal relationship. Judicial separation serves as a distinct statutory alternative. This mechanism suspends the mutual duties of the couple, specifically the duty to cohabit, without legally ending the marriage or civil partnership. The statutory basis for these pathways is found in the Matrimonial Causes Act 1973 for marriage and the Civil Partnership Act 2004 for civil partners. Both pieces of legislation contain the specific provisions required to facilitate judicial separation. A judicial separation order terminates the duty to live together and provides access to financial remedies, while the central legal bond remains intact. Because the legal union continues, practitioners must navigate a specific set of statutory exceptions that do not apply to a standard divorce. We can evaluate the two pathways using a statutory matrix across 5 dimensions: status, timing, finances, pensions, and estates. Regarding legal status, Section 17 of the Matrimonial Causes Act is explicit. A judicial separation order does not end the marriage, and the parties are not legally permitted to remarry. In a divorce, the final order terminates the union and permits both parties to enter into a new marriage. The timing dimension is governed by Section 3 of the Matrimonial Causes Act and Section 41 of the Civil Partnership Act. These sections prevent a party from applying for a divorce or dissolution within the first year of the relationship. Section 17 provides an exemption to this rule. Judicial separation is available immediately, allowing for court intervention within the first 12 months of the marriage. Like a modern divorce, judicial separation no longer requires proving specific facts, such as adultery or unreasonable behavior. The procedural requirement is now a statement by one or both parties confirming they seek to be judicially separated. For relationships that collapse within the first year, judicial separation is the only statutory route to immediate court protection. In the finances dimension, the family court retains broad jurisdiction. As shown in the Matrimonial Causes Act, the court possesses the power to make most financial and property orders. Practitioners can secure maintenance pending suit, ongoing periodical payments, and property adjustment orders to address the family home. However, Section 24B prohibits pension sharing orders. This means the pension fund cannot be immediately split between the spouses, as it would be in a divorce. While splitting the pot is barred, pension attachment orders under Section 24C are still legally possible. These allow a portion of the pension income to be redirected once the holder retires. A second exception involves the clean break duty. Under Section 25A, the court typically must consider whether it can sever the financial ties between divorcing parties to allow them to live independently. Because parties remain legally married in a judicial separation, the court is not under a duty to immediately terminate financial obligations to one another. In divorce, the court follows the sharing principle, a presumption that matrimonial assets should be divided equally. In judicial separation, that presumption is replaced by a focus on the parties' ongoing needs because the legal union remains in place. Judicial separation secures the home and immediate maintenance, but it leaves the parties financially connected through their pensions and ongoing support duties. The continuing legal bond creates specific risks within the estates dimension. A judicial separation order triggers Section 18(2) of the Matrimonial Causes Act regarding intestacy. If a party dies intestate while judicially separated, Section 18(2) prevents the surviving spouse from succeeding to their property. This bar only applies to intestacy. If a formalized will exists, judicial separation does not automatically revoke it, and the separated spouse is not treated as having predeceased the testator. This creates a liability. A separated spouse can still inherit an entire estate under an existing will, unless a new one is drafted and executed. Property owned as joint tenants is also unaffected by the separation order. The practitioner must serve a separate notice of severance to convert the ownership into a tenancy in common. This legal framework mirrors cohabitation, where no statutory inheritance rights exist unless they are explicitly recorded in a will or property deed. To protect the client's interests, the practitioner should advise on redrafting the will and severing joint tenancies simultaneously with the separation application. Judicial separation creates a legal middle ground. Some succession rights are severed by statute, while others remain active, requiring proactive estate management. There are two primary strategic reasons to utilize judicial separation in modern practice. The first is immediate year-one intervention. When a marriage collapses within the first 12 months, this mechanism is the only way to obtain court-ordered financial and property protection. The second use case involves clients with religious or ethical objections to the finality of divorce, who still require legal and financial independence. If a client later chooses to divorce, they must file a new application once the one-year bar has passed. Practitioners must ensure the client understands that they remain legally married, that they cannot legally remarry, and cannot utilize pension-sharing orders. While the use of this mechanism is declining, it remains a specific procedural option for the family court in the Matrimonial Causes Act and Civil Partnership Act. Mastering these critical statutory differences allows practitioners to provide robust, strategic advice to clients navigating complex relationship breakdowns. For updated guidance on digital application processes and the 2025 module specifications, practitioners should refer to the current family procedure rules and professional updates shown here.